You need to go up there, you need to avoid the gangs, you need to keep your head low and your nose clean, follow the rules, and get through this, okay? Come out, you can do it, okay? I'm not sending you to prison to make you a worse person, okay? Come out better. 170, the State of Ohio versus Derek Banks. Mr. Banks is before the court with his counsel, Mr. Lewis. Ms. Tranter, on behalf of the State of Ohio. Ms. Tranter, we are set for plea. What are we doing?
We have presented Mr. Banks with an offer which includes a plea to the felonious assault, a plea to the aggravated vehicular assault, as well as the fail to comply with this order signal of the police officer and receiving stolen property for a combined sentence of 6.5 years in the Department of Corrections. My understanding as we sit here today, I do not have a signed plea form. I will tell the court, as you're probably aware, I believe this is the 5th time we've been here on this particular case. The offer from the state expires today at the end of this hearing. If Mr. Banks does not want to accept that, then we're going to have to get a trial date.
Could you, I'm sorry, could you tell me again what the offer was?
Yes, the total offer is 6.5 years, would be 3 to 4.5 on the felonious. I think do you have the plea form there, Mr. Lewis, in front of you? So
Yeah,
just so I can tell him how we structured it. Okay, yeah, 3 to 4.5 on count 1, which is the felonious. Count 2 being the aggravated vehicular, 18 months. Count 4, 24 months. And count 5, 18 months. All counts except for count 5 are to run consecutive to each other. Count 5 would run concurrent.
May it please the court? Yes, sir. Your Honor, for the record, Carl Lewis on behalf of Derek Banks in the courtroom is present with his mother, father. I've had an extensive conversation with Mr. Banks, with his mother, with his father. The most difficult thing, Your Honor, for this young man in the court does not, and I explained that to him, get into plea negotiations. Ms. Tranter has been working with me, and I appreciate her patience. This young man has never, ever been in trouble before, and the prospect of the 6.5 years is startling to him. I've cautioned him and advised him that it is in his best interest to accept this plea resolution. He was asking again for more time, and we could meet again and again. His concern, as well as his mother and father, they understand this is a serious offense. They understand that the charges are significant. It's just difficult for mom and my client to accept that he has to go to the penitentiary for 6.5 years. I've explained to him that if the court was gracious enough to speak with us about the F1 felonious assault at the last hearing, it was our intention at that time to maybe try the case until we reviewed the law with respect to purposeful versus knowing. And my client understands what the instruction would be to a jury, what this honorable court would consider if this case were to go to trial, has not made a decision whether he's guilty or not guilty, but clearly it is my opinion we would not prevail on the failure to comply, the vehicular assault, or the receiving stolen property, and that carries a potential maximum of 8 years. So I've cautioned my client that I would ask the court for maybe 2 more weeks to consider this plea. Ms. Tranter has made it abundantly clear that the state will not offer this if the plea is not taken today. And I explained to my client, if the court denies our request today, what is your pleasure? And it is my expectation and hope that he would take the plea if the court's not going to grant us another 2 weeks to consider the plea. And I believe his mother wanted to address the court regarding a little more time to discuss the plea with her son.
Ma'am, did you want to speak to me?
Step over there. You have to step to the deputy.
Can you come on up?
Step up here to the table.
State your name for the record.
Taisha Hill. Like his lawyer was saying, like he never been in trouble before.
Okay, here's the thing. I'm going to stop you right there because, again, he's not been found guilty of anything, okay? I understand he's being held in jail in lieu of posting bond, and I get all of that. But right now's not the time. I don't know enough about him. You know a lot more than I do. The attorneys know. I know what he's charged with and what the general allegation is. I do not know the specifics of the case, and it's that way for a reason. Okay, and what Mr. Lewis has said, he has no prior record. Obviously, he started off here with these charges are very, very serious. But now's not the time to ask me to be lenient, because I'm not sentencing him today unless the attorneys agreed on a sentence. So in looking at in what they've offered or what he's charged with, the felonious assault, again, since it's a felony of the first degree, that is an indeterminate sentence. It's called a Reagan Tokes. So that would have, the range of penalties would be from 3 to 11 years minimum term. The maximum term on that would be, let's say, 11 to 16 and a half. So it's whatever that number is between 3 and 11 plus half of that number.
I'm good. I think we're good, Judge.
Okay.
So do you want to do?
So I don't do a PSI if I do.
Right, you gotta get this, with this, what's on that form. You have 2 minutes, Judge?
Yes, sir.
All right, have a seat, sir.
All right, Mr. Banks, they're telling me that you are going to change your plea to guilty to 4 of the counts from the indictment. Before I get to your change of plea, I am required to go over some things with you, okay, sir?
Yes, sir.
Yes, sir.
How old are you?
I'm 20.
And how far did you go in school?
I graduated enrolled in the University of Cincinnati.
So you're able to read and write, okay?
I'm sorry.
You can read and write?
Yes.
Are you a citizen of the United States?
Yes.
Has anyone promised you how the court would sentence you other than this agreed recommended sentence?
No.
Has anyone threatened you in any way to get you to plead guilty against your will?
No.
Are you satisfied with the representation that you received from Mr. Lewis?
Yes.
Are you currently under the influence of any drugs or alcohol?
No.
Do you take medication that interferes with your ability to understand what's going on here today?
No, sir.
I have in front of me a document. This is called a change of plea. On the 3rd page, on the line marked defendant, there appears a signature. Did you sign this?
Yes. Yes, sir.
Did you read this and go over it with your attorney before you signed it?
Yes, sir.
And you feel comfortable that you understand what it says?
Yes, sir.
This document says you're entering a plea of guilty to 1 count of felonious assault. That is a felony of the 1st degree. Ms. Tranter?
Your Honor, the facts that are alleged in the indictment, these incidents occurred on November the 15th of 2025. Warren County, state of Ohio. On that date, the defendant was seen operating a vehicle at a high rate of speed by Trooper Aldetta. He did pursue defendant, activating lights and sirens. Defendant continued to operate the vehicle at a high rate of speed, reaching speeds in excess of more than 100 miles per hour, weaving in and out of traffic. Multiple agencies did end up becoming part of this pursuit, including Middletown, as well as Franklin Police, who ultimately performed a pit maneuver, and the defendant's vehicle was able to finally be brought to a stop. During the pursuit, he did collide with a civilian, causing injuries to the driver of that vehicle, who was transported to Miami Valley Hospital. For her injuries, serious but not life-threatening, as well as there was a collision with a Middletown police officer in his vehicle, and the vehicle that the defendant was operating was found to be stolen.
Mr. Lewis, anything on those facts?
Respectfully, Your Honor, nothing on the facts, nothing more to add, stipulate to what's been read into the record by the state.
Mr. Banks, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
Yes.
And again, you understand all the rights you're giving up by entering a plea of guilty, the rights we went over.
Yes, sir.
What is your plea, sir?
Guilty.
All right, the court's going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we have discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty.
Yes, sir.
Ms. Tranter, anything before I sentence him?
Judge, we would ask that you would, if the agreed recommended sentence in this case, in addition to that, we are requesting restitution in the amount of $500 to Eric Lane, who is the owner of the vehicle, for damage that was that occurred to his vehicle during this pursuit. We would ask for a lifetime license suspension as part of the sentence, and I calculate the defendant's jail time credit today as 157 days.
All right, Mr. Lewis, anything before I sentence him?
Judge, just briefly, the court has heard through our numerous discussions that this young man is never thought he would be here. He's highly intelligent, graduated, was in college, chose to engage in some activity that has landed him here today, And I told him as we were preparing for this case, you hit the grand slam in terms of criminal offenses. And unfortunately, and I appreciate the state of Ohio, Ms. Tranter, in terms of our negotiations coming to this number, I was desperately looking to get a lower number for this young man. I continue to pester the state, this honorable court, in terms of reaching a sentence that was lower. He's 20 years of age, never been in trouble, going to the Ohio Department of Corrections, and wants to desperately get back to his mother, his father, his siblings. And it's been difficult for him to comprehend that he's going to spend, if the court follows the recommendation, 6.5 years in the Ohio Department of Corrections. He will do everything he can to make himself better by education, anything he needs to get involved is positive. It's been an honor for me to represent this young man, and I hope that, as painful as this is for he and his family, that he can return to our society a productive, law-abiding citizen. And with that, I would remain silent.
Mr. Banks, is there anything you'd like to say?
I just want to say I want to apologize to the family that I involved in my foolish actions. I want to apologize to the officers and my family for letting them down. I never intended to cause any harm. I just panicked, made a stupid, young, dumb decision. I'm sorry. I never meant to do any of it.
Ma'am, I'm going to give you another opportunity. If you would like me to know something in addition to what's already been said, if you'd like to say something, now would be the time to say it, because I am going to sentence him now. I need you to come forward. Okay. All right. All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and will find it to be an appropriate sentence. So on count one, the felonious assault, the court will order you to serve a minimum term sentence of 3 years and a maximum term sentence of 4.5 years. On count two, the court will order you to serve a sentence of 18 months in prison. On count four, I'm ordering you to serve a prison sentence of 24 months in prison. Count four and count one by law must be served consecutive to each other. The court is also ordering count two to be served consecutive to count one and three. The court finds that the consecutive sentence is necessary to punish the defendant. It is not disproportionate to the conduct or danger posed by the defendant, and these offenses are part of a course of conduct that the harm caused was so unusual the single prison term would not adequately reflect the seriousness of the conduct. And on count number five, the court's going to order you to serve 18 months in prison, that to be served concurrent with counts 1, 2, and 4. You have 157 days jail time credit. The court is going to order restitution in the sum of $500 to Eric Lane. Other than that restitution order, the court's going to find that you're indigent for the purpose of other fines, costs, or financial sanctions.
Thank you, Judge.
I am going to order an operator's license suspension for your lifetime. Now, I know I'm saying lifetime now, but that doesn't necessarily mean that I'm going to stick to this order. So when you are released from prison, if you're doing well and you don't drive, because if you're going to drive without a license, then I'm not going to give you your license back. But I do have the ability to rescind this or terminate this suspension at some point into the future.
Yes,
So,
yes, sir.
so just be aware of that. I'm ordering lifetime now, but I want to see you get through this. Now, you're also subject to this mandatory post-release control, which I spoke about a minute ago, which means when you're released from prison, the adult parole authority is going to supervise you for a period of time. Do you understand that?
Yes, sir.
If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. And again, they can supervise you anywhere from 2 to 5 years. So if when you're placed on PRC, it's going to be like you're on probation for them, okay? If you go out and commit another felony while you're on PRC, post-release control, then the sentencing judge can add PRC time to whatever sentence he sentences you to. And that would be whatever time you have left on PRC or a year, whichever's longer. But when you're on a 3 to 5 year PRC, or 2 to 5 years, That could be longer than a year, okay? You do have a right to appeal court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, all of that can be provided to you at no cost, including an attorney. Do you have any questions for me, sir?
No, sir.
All right, I know it seems like it's the end of the world. I get it, okay? You need to go up there, you need to avoid the gangs, you need to keep your head low and your nose clean, follow the rules, and get through this, okay? Come out on the other side a better person, come back to your family. I know it's probably easier said than done, but you can do it, okay? I'm not sending you to prison to make you a worse person, okay? Come out better, okay? All right,
Thank you, Judge Tepe.
thank you.
All right.
All right, taking exit 36. Going westbound. Clear. Westbound on 123. I need a supervisor I could pit.
What's your speeds?
I've just asked for permission if I do get down to the speeds for a bit. He's driving oncoming traffic.
If you get the speeds and traffic's lighting up, make sure you got cover.
Okay, I got Middletown officers behind me as well, so I have additional units coming up to the roundabout at Sunny Brook.
Well,
Alright, we're going back in the park, block him in here. Alright, I'm at 30, I'm gonna pit. Pit. Driving through, coming back out. We took out a Middletown cruiser. Go. I think he had a Middletown cruiser head on.
he's losing a tire.
Alright, coming up to South Main. Traffic is light to medium. Blue to red light. Alright, he's losing all over the place. Coming up the river.
One foot, northbound.
Start squad, we got an injured person. Start the squad. Back alley. Stay there. Got her. What's the address here?
He's caution subject. We need to find a passenger. 502 other, go ahead and turn in.
What do you need? I think they got out. No passenger. Who's the passenger?
Which truck is he? You broke out. This truck and on-ball injuries.
Hurt at that leg.